The state has no statement, no proof, no witness. Baloyi files heads of argument instead. And Judge Ratha looks away. South Africa, pay attention.
On the night when you were arrested, on a Monday in June 2020, you were sleeping in the S section of the hostel. Is that correct?
Ubufakazi bakho ke mnumzane ushilo ukuthi ke ngomsombuluko ebusuku owaboshwa ngawo ngoJune ka2020 wawuleli ko S hostel.
Yeah.
Yes.
But were you not staying in the N section of the hostel?
Kodwa ke ingabe wawungahlali ko N yini?
Ngaboshwa eS ngilele khona.
I was arrested at the S section. That's where I was sleeping.
Mr. Zungu, the question is, were you not staying at the N section?
Umbuzo ke babuzungu uthi wawungahlali ko N yini?
Angihlale lapho ngidla khona.
I don't stay.
S lapho
Okay.
ngithola khona amaphoyisa.
Okay. I don't reside at the N section. That's where I normally eat at the N section. I reside at the S section where the police found me or arrested me at.
In the statement that is in your name, which will revert to at a greater detail at a later stage, you give your address as residing at number N6/3 block N, Baswitino Hostel.
Objection. Objection. The state cannot say that that statement belongs to this witness. The state has got to prove that statement before it starts to cross-examine on the content of that statement. But it cannot stand up and say on the statement which is in your name. The state must prove it first before it starts to cross-examine this witness on the content of that statement.
Yes, sir.
2 points, Malot. Firstly, Mr. Zungu himself says a statement was made and he was asked to transfer on the statement what accused number one, Mr. Sibiya, said. That is the first thing. Secondly, Malot, the defense themselves have cross-examined witnesses on the statements of other witnesses. And the issue didn't occupy them at that stage, my lord, that the statement hadn't been proven. They cross-examined on statements of a number of witnesses, and some of them have even been handed up, my lord. We're surprised that they are raising this point. But legal speaking, my lord, the witness hasn't, as we mentioned, he mentioned that he signed the statement, he placed an S on the statement. He's just putting the, he says the contents were transferred from what accused number one said to this document. So we submit, my lord, that we can cross-examine on the statement.
Is it a statement? Or is it a document?
It's a statement, my lord.
Yes, Mr. Nisi, what's your view?
The state must prove the statement before it cross-examine the witness on the basis or on the content of that statement. It must prove it. If the state has got a problem, how to prove a statement, then it must say so, will assist him. But he must prove it.
Yeah, prove the statement, Mr. Baloyi.
Well, I'm sorry, my lord.
Prove the statement.
Yes. Well, firstly, as we've indicated, my lord, the witness said that on the 24th, Mr. Zungu, on the 24th of June 2020, he was in the presence of Brigadier Gininda, and that Brigadier Gininda then took down a statement. He transferred what accused number one was saying to this document, the statement that is being referred to. My lord, this issue is very crucial. And we are going to refer to the statement in greater detail at a later stage. If it
Yeah,
is-
but please, I'm making a ruling. Prove
yes,
it. Prove
if
it.
it is, I'm sorry, my lord, if it
Prove
is,
it. Prove the statement.
if it is necessary, the
Yeah.
point need to be argued.
Yeah, right.
And we'll suggest that heads be filed. We'll agree on a timetable to argue this specific point.
Yes, Mr. Nisi.
The state is making an order, a ruling that, the court is making a ruling that the state must prove the statement. The state comes out through Mr. Baloyi and say, no, if it needs to be, we can file heads and argue this point. That's not what the court is saying. And even so, that suggestion or that ruling must also come from the court, not from the state. It
Yeah,
must come from the presiding
fine.
officer. The court is now saying, Mr. Baloyi, can you proceed to prove the statement? He must do that.
No, fine. But if he wants to file heads, he can do that.
Yes.
If he wants to file heads.
Thank you, my lord.
Right. You know, I'm shocked at the behavior of advocates. Shocked.
We also shocked, my lord. In as much
You're
as the
behaving
court
like
is
children.
shocked. No, we also
No,
shocked.
no, I'm making the remarks.
Yes, my lord. We
And you
also
shut
shocked.
up. You shut up. I'm making the remarks.
Thank you, my lord. Shut up.
Yeah.
Thank you.
I'm shocked.
Yes.
One advocate says, I showed them, nobody was interested. No, he never showed us. We asked questions, blah, blah. And we are all court officers. Go to the jail.
What unfolded in court should alarm anyone who still believes justice is blind. Judge Ratha expressed shock, not at the collapse of the state's case, but at defense advocates doing their constitutional duty. Meanwhile, Advocate Baloyi was unable to prove Gwabini's alleged statement. No confirmation, no witness validation, no evidential foundation. Instead of leading evidence, Baloyi opted to file heads of argument. Let's be clear, heads of argument are not evidence. They do not replace testimony. They do not cure contradictions. They do not prove disputed statements. Yet the court's most visible reaction was reserved for the defense, not for the state's failure to stand up a core allegation in a murder trial. That imbalance matters. When cross-examination is treated as misconduct, but evidentiary failure is treated as normal, the scales of justice tilt dangerously. The defense is not on trial for asking questions. The state is on trial for proving its case. And right now, it cannot. If a statement exists only on paper and cannot survive scrutiny in open court, it has no legal weight. Allowing arguments to stand in for proof risks, lowering the standard from proof beyond reasonable doubt to trust us. This is not about personalities. It is about precedent, and it is about whether courts demand evidence or accommodate its absence. Should a judge be more concerned by tough cross-examination or missing evidence? Can heads of argument ever replace proof in a criminal trial? What message is sent when the defense is rebuked but the state's failure goes unchallenged? Leave your comments down below. I read every one of them. Thanks very much for watching. Please don't forget to like, share, and subscribe. If this channel gives you clarity, courage, and the truth others avoid, hit join and stand with us. Your super thanks keeps independent voices alive and the truth uncompromised. I'm Skybridge. Till then, good night.